number 78, People versus Lance Rodriguez. We are pleased to be joined by our colleague John Egan from the Appellate Division 3rd Department.
Good afternoon. May it please the court, Hannah Khan on behalf of Appellant Lance Rodriguez. May I reserve 4 minutes for rebuttal?
Yes.
The question that is before this court is whether Officer Schell effected a seizure when he commanded Mr. Rodriguez to stop and pulled him over on a public road. Because if that was a seizure, it was an unlawful one. It is undisputed that Officer Schell did not have reasonable suspicion of a crime, probable cause of a traffic violation when he initiated the seizure.
So is that your argument now, that is it that this stop amounted to a seizure, or are you asking for a per se rule that any stop of a bicyclist on a public roadway is a level 3 automatic? What are you asking this court to decide?
Yes, I think that the rule should be, like it is for cars and motorcycles and all other vehicles, the rule should be that on a public road, anytime a police officer asks a bicyclist or any vehicle on the public road to stop, that's a seizure, because it's always a mandatory encounter. It's not consensual. No reasonable person would feel they are free to disobey or disregard a police command to stop on a public road.
What about the claim that there's a difference between a motor vehicle and a bicycle?
Well, I don't actually think that is true in terms of what a reasonable person thinks that they can do on the road, because we know the VTL requires everyone on the road, whether they're on a bicycle or a scooter or a hoverboard, any of those things, requires them to stop when police tell them to stop. There's a lawful order doctrine.
So is it an important distinction between a pedestrian walking versus a bicyclist is that they're in the roadway and they're in motion when they're told to stop in the roadway? Is that what makes it a difference from being a pedestrian walking?
Yeah, I think what the difference is if the operative fact here is the public road. What do we have to do in a public road?
Does a person who's running in the public road get the same rule then?
Well, yeah, and again, you would just look at what does a reasonable person expect. And a person, first of all, running, public roads are not designed for runners and pedestrians.
Well, not designed for a lot of stuff on them, but, so a person, there's people running the road all the time, just like ride the bikes on the sidewalk, but you're running in the road, there's no sidewalk, let's say. You're running in a public road. Do I get the same rule as a bicycle rule?
If they're actually in the road, then they're not supposed to be in the road. It's a violation of the
But
VTL, so you could
there's
stop
no
them.
sidewalk. You can't be in the road, how do you go?
So if there is no sidewalk and there's no shoulder, you're supposed to be all the way, to the right. And yeah, if there's a runner in the road, running down the road, and police say, like they did in this case, for example, police, hold up, then I think a reasonable person who's in the road thinks that they have to stop.
And that's level 3.
So
And they
the
would need a
rule is
level 3.
anyone in the road, do you have to be running, or if you're walking in the road, that would also apply?
Yeah, I think so, but again, that's not
You're
really
in a
implicated.
crosswalk.
Crosswalk is a pedestrian area. And I'm not
But there are
advocating.
some places in upstate New York where there are no sidewalks and person is literally walking along the roadway. Are you saying because they happen to be walking along the roadway, it's the same as a motor vehicle?
No, what I'm saying is that you always look at what a reasonable person in that situation would think. A reasonable bicyclist on a public road knows that they have to comply with the same rules as cars and knows that they have to stop. There is no reasonable person who thinks they can disregard a police command to stop when they're bicycling down a roadway.
What if the bicyclist is already stopped? Let's say I'm on my bike, but I stop at a red light and the police come up.
Well, it's the same rule as cars, I think. You can,
So it's the motion doesn't really matter.
well,
Right,
no, I think it does. I think when cars are parked or stopped, you don't require a level 3. So I think it would be the same rule for any bicyclists or.
Wait, so your understanding of the law is if I'm driving in my car and the police want to stop me, but they don't have a level 3, all they have to do is to wait till I get to a red light and stop, and then it's no longer level 3?
Would, no, I think I think I might have misunderstood the
Okay.
question. So I think that the bike rule, or it's not really a bike rule, I think public road rule requires that, like cars, if someone is driving down the road on a bike,
They have to obey the vehicle and traffic law, just like
Correct.
drivers of cars, correct?
correct.
Isn't there testimony here at the suppression hearing that the officer observed your client driving down the middle of the road and cars having to stop or get out of the way?
So my client was not violating any provision of the vehicle and traffic law.
So
He
you're
was-
saying there isn't like a reckless bicycling law, the way there might be a reckless driving law?
Right, and I also want to note that driving down the middle of the road in this instance was actually compliant with the VTL. There's no bike path, there were cars parked on both sides. so people-
Bicycles don't have to stay to the right?
Well-
Stay out of traffic?
Right, this was a narrow road, and what the VTL says is that you have to, the bicyclist should bicycle in a way that's safe, and in this instance, it was safest to go down the middle of the road. He was going in the right direction. The fact that cars had to go around him isn't indicative of recklessness. In
But
fact,
isn't the fact that the VTL seems to treat bicyclists somewhat different than it treats motorists undermining of your argument that for purposes of search and seizure, they should be treated exactly the same?
No, because I think what the VTL, the relevance of the VTL here is what would a reasonable person think? Everyone on the road has to comply, because the reason why the VTL has carved out all these different laws for roads is because they're dangerous. So police
So
need
it's
to have.
anything on the road, but wouldn't you, don't we have cases where pedestrians, if you do this to pedestrian, they think they have to stop? I mean, they're going to respond to authority. We have cases like that with pedestrians.
In the public road?
On the street. Why wouldn't a pedestrian walking down the sidewalk and the police officer says stop, why wouldn't they stop? They don't think they have to?
On a sidewalk?
Yeah.
Well, for starters, the lawful order doctrine applies to public roads, not sidewalks. I think that the rules for
Saying what a
pedestrians.
reasonable person, I thought we were talking about what a reasonable bicyclist would think. Wouldn't a reasonable pedestrian think the same thing?
On a roadway or on a,
Sidewalk.
no, because the rules for pedestrian areas are different. They don't implicate the same safety concerns. Police are not given the same broad authority that they are given on the roads. That authority is important because they need to ensure our safety. But
Your
when they
client
use-
was not in a pedestrian area.
Right, he was on a road, and so he was required to stop when Officer Shell told him to stop, and because of that, he was seized. That was a seizure. It's a non-consensual encounter. Police have been, the legislature has given police this broad authority, but they have to exercise that authority in a
He
constitutionally
didn't
sound
stop
manner.
the first time the officer asked him to stop, did he?
No.
Didn't he say he had to do it twice?
Yes, he
Could that
commanded
be
him twice.
taken as some evidence that he didn't personally believe that he needed to stop, as a bicyclist, that he needed to stop just because he was in the roadway?
No, absolutely not. So again, this was a very quick command that he obeyed. There's no
But
dispute.
I'm
that
talking
he-
about when he disobeyed it the first time, though.
I think it was very quick and repeated, but in any event, it's what would a reasonable person think? So a reasonable person knows they have to
When
stop.
the second command was made, the police clearly said, police. They wanted the rider to know they had authority over him,
That's correct.
arguably?
Yes. Actually, I think both times they said
Yeah, they didn't,
police.
they said it the first time as well, right?
Police,
Well, I
yeah,
don't think
stop.
we're saying that there can never be a seizure of a bicyclist, right? Our case law doesn't say that, absent this rule. And you keep saying reasonableness, but the thrust of our jurisprudence on these De Boer standards is reasonableness and the totality of the circumstances. So why isn't that assessment, I think this whole discussion lends itself to a totality of circumstances analysis that would better fit the circumstances. Is someone running too fast? Is a bicyclist going too slow? People on a hoverboard in a public roadway? Like, why not look at the individual circumstances like our laws currently require us to, and then make an assessment? Was that criminality afoot? Do we need reasonable suspicion? The situations on the street are fluid and change constantly, and doesn't a per se rule take away almost the reasonableness angle of this?
No, Your Honor, the same reason we need a per se rule for cars. You know, there are thousands of New Yorkers who are bicycling to work every day on our public roads, and they should not be subject to more police intrusion, to less Fourth Amendment protection, simply because they cannot afford a car.
I'd like to get back to something that Chief Judge asked you before your time runs out, which is stopped bicycle, stopped car. Now, my understanding is stopped car, still, you go up, seizure, or no?
Yes, I think stop, not a parked car.
Right,
Stop car,
stop.
seizure.
So
yeah.
stopped bicycle, same rule, stopped hoverboard, same rule, stopped scooter, stopped
On a pu-
skateboard?
On a public road? Yes.
So someone has a skateboard and they're stopped on a public road, and you come up to them, that's a seizure.
Yes, because they are required to stop by law.
And
They are
if the
required.
skateboard is stopped on the sidewalk?
Different rule. Pedestrian areas, different rule. The legislature has really carved out different roads because roads are so dangerous. Sidewalks don't implicate the same safety concerns.
You haven't been in
Pedestrian
New York
areas-
City lately, maybe.
Pedestrian areas don't implicate those same safety concerns. But stops on the road, they're always mandatory, so they're always seizures.
All right, you're arguing it's a level 3 stop, correct?
Yes.
All right. Supreme Court and the Second Department analyzed this as a level 2 stop?
Correct.
All right, assume you're right. What do we do here?
Well, then you should find that the seizure was unlawful and the evidence from the resulting search needs to be suppressed.
Is that within our power, or was this a case of Supreme Court utilizing the wrong legal standard, and therefore would have to send it back to apply if we say it, agree with you that it's a level 3, apply a level 3 standard to the facts as found?
No, not in this case, because there is no record support at all for the fact that there might be reasonable suspicion, and the people have waived any argument. They've never argued that there's reasonable suspicion. There's no dispute about that.
As to a crime?
As to a crime or probable cause of a traffic violation, there's no dispute in the record that that did not occur. So no, I don't believe that you would need to send it back for that determination. I see my time is up.
Thank you.
Why isn't it a seizure when a bike is in motion on a public highway and the police command that it stop in traffic?
Well, Your Honor, before I answer that, if I may just say, it can't be said that the lower court, the Supreme Court, and the appellate division made the wrong decision based on the facts in this case, that this was a level 2 civilian police encounter. And based upon the facts of this case,
The facts of the case?
Yes.
We're on a public roadway.
we're on a public road, Your Honor, but it is,
Why is the bicyclist treated differently than a motor vehicle? You have motorized bikes now.
well, we're not, correct, Your Honor, but we're not advocating that bicyclists should be treated specifically different than motor vehicles. There may be situations where bicycles could be treated as motor vehicles. For example,
But the
if it's
question, I
an
think,
e-bike.
the question that you're, sorry, right in the
Sure.
middle here. The question that counsel has posed to us is, shouldn't we have a rule for bicycles that is the same as all the rules we have for motor vehicles?
Absolutely not, Your Honor.
Okay,
There are
so-
many different
So
levels.
that goes to Judge Troutman's question.
Correct.
So what about a motorcycle?
Depends on the situation. A motorcycle could be treated as a motor vehicle. They go
but
at much
should-
faster
but-
rates of speed
Right, but you keep saying depending on the situation.
because it's the totality of the
So
circumstances
that
test.
you're
Your Honor.
saying even for motorcycles, you would say they should not be treated the same way as cars?
Well, there are situations where a car could even
No.
be treated.
Oh, so you don't think there's a,
There's a general rule.
yeah,
The courts have said generally a motor vehicle is a level 3 seizure because of the level of intrusiveness that entails to stop a motor vehicle.
and so
The
generally,
lights,
would
the
you say,
sirens.
would you say the same about a motorcycle?
I would, Your Honor. I would say the same
So
generally.
how about an electrified bicycle that travels 30 miles an hour?
It may in that particular situation.
So
If
is
the police-
motorized what makes it different?
No, I think, Your Honor, it depends on the level of intrusiveness. And that's what this court's
And how do you
jurisprudence
measure
has said.
that?
Yeah.
Is it by the speed? Is it by the location on the roadway? How do you
It's
measure
the
that?
totality of the circumstances.
I mean,
How do,
Again, what would be the factors one would look at to figure out, under the totality of the circumstances, whether or not it's a seizure?
how is that individual stopped? How is that car, e-bike, bicycle, pedestrian, how is that individual
Okay, so in
stopped?
this instance, the bike is in motion, it is
Correct.
moving. Why is it not intrusive for a police officer to repeatedly command that you stop? Why is that not intrusive?
It's not intrusive, Your Honor, because the bike, the defendant was going in the middle of the road, causing other cars to swerve out of the way to avoid hitting him.
So it's not intrusive because of the manner in which he was operating the bike?
Well, it's not, that's the problem with this per se rule that my adversary is trying to advocate. It doesn't work because, let's take the facts of this case, which we are bound by these facts, for example. What was the police going to do? Were the police, they saw this was a public safety issue. This
If
was
they have
a danger.
cause to believe that he's committed a violation of the vehicle and traffic law, wouldn't you apply, you could, the question is, can you apply it the same way as you would with a car?
Well, yes, Your Honor, you can.
And bikes are supposed to observe, they don't always observe the vehicle and traffic laws. But
Exactly.
bicyclists, I'm not saying they're allowed to just ride in an unbridled way.
Correct.
In this instance, you're saying this was not a seizure because of the manner in which he was operating?
No, I'm saying that in this particular case, there's two components. One, the police enforcing their own public safety. They see this defendant riding in the middle of the street. Cars have to stop to avoid hitting him. The police had the right, whether or not this rose to a VTL violation, and it may be, again, not in the record, he wasn't charged with this, it may be a VTL 1212
Did he need to
reckless
be, by
driving.
the way? Seems
I'm
like
sorry?
there's a lot of cases where, a trooper stops a car on the thruway for speeding, and then things develop and drugs are found and there's a felony arrest made. There's no necessarily ticket issued for speeding, but that was the basis for the stop.
Correct.
Okay.
Yes, Your Honor, that's my point. So there,
Was there a V&T violation here? We know
I'm
there was
sorry,
no, a V&T
what
violation.
is
Vehicle and traffic law.
VTL, thank you, Your Honor. We do not know, it wasn't in the record. The officer's testimony
And
was,
that's the point.
Is that,
but that's not required, Your Honor, that
But
there
the
actually
point
be
is,
a
you raised concerns about safety and the manner of operation and danger to the public. But if there is a violation that's occurring, of course the police have the right to stop them, charge them with that vehicle and traffic violation. And you are agreeing that this record doesn't support there was even a violation.
It's not, on this record, it's not clear that there was a VTL violation.
And you're saying it doesn't matter.
Correct, because there are many levels. The VTL violation could be a predicate for a stop, and that's certainly whether it comes to a motor vehicle, a bicycle, and there
Counsel,
are a myriad of cases.
sorry.
I'm sorry.
I'm lost, so I just need you to help me get back on, I was going to say help me get back on the road, but get me back on track. You started this line of questioning by saying that the rule is keyed to the intrusiveness of the police action, and somehow it's more intrusive for police to stop a vehicle than it is to stop a bicycle. And then we sort of swerved, if you will, into, I don't know, reckless riding of a bicycle or maybe even violating VTL provisions. And I don't see the connection between that and intrusiveness. So are you articulating two standards, or is there a connection that I'm missing here?
I understand your question, Your Honor. No, I was answering Judge Troutman's question that based upon the facts of this case, there was a recklessness component. So the predicate for this police-citizen encounter in this particular case was, one, the safety of the
But
defendant.
I think you admitted to Judge Troutman that there is no reckless bicycle riding provision in the VTL.
No, not on this record, it's not clear, but I believe, again, off the record, that under VTL 1212, the reckless driving can also apply to a reckless bicyclist.
So are you
But
saying
again,
that the
that's not on
police
record.
had probable cause to believe that this defendant had committed a VTL violation at the
No, Your
time they
Honor.
stopped him?
On this record, I'm not saying that.
So that's out of it,
I am,
right?
correct. I am saying that the VTL violation can be a predicate for the stop, and under Robinson
So
and
the
Hinshaw.
predicate here is what?
So the predicate here is twofold. The predicate is first the initial common law right to inquire when they saw the defendant riding his bike in a reckless manner, and then seeing the bulge in his waistband, which is the telltale sign of a weapon, which, according to this court's jurisprudence, would rise to a level 2 common law right to inquire. And that's what you have to look at. You have to look at the particular facts of
I
this
thought the record
case.
showed that his hand was in his jacket pocket, not his waistband?
His hand was over a bulky, did I say jacket pocket?
No, I think it was
His
jacket
hand was
pocket in the
over a
record.
bulky item on his waistband. So the police then said, stop, hold up.
So let me get you back to intrusiveness for a second. How would you measure the difference in intrusiveness between stopping a bicycle and stopping a car?
Generally, it's much less intrusive. A bicycle could be on a bike path. A bicycle could be in a bike lane. A bicycle could entail the officer to communicate with the bicyclist, whereas a car on a roadway, on a highway, would be much more difficult, and it's usually not occurring without the lights and sirens and the stop. The other way is, what if the police want to investigate a crime and see an individual on a bike riding, and they say, hey, can we just ask you a question? Did you see any witnesses? We're investigating this case. There's a much easier level to communicate with a bike than there is a motorist, but again, that's the problem with the
Why?
per se rule,
Why is there easier?
because you could, let's say an individual's on a bike lane, and the officer could be on foot patrol, and he's like, hey, can I just ask you a question? Can I pull over? But again, speed, all those other things come into play.
They do come
They
into
do.
play. They have bike lanes now
Yes.
designated.
Yes.
And more people are riding their bikes.
Absolutely.
And they're riding them at excessive speeds. It's
Yes.
not as easy as you profess.
Oh, exactly, that's my
But
point,
isn't
Your
that really
Honor.
the point, though, that,
That
so
is
if
the
Lance
point.
Armstrong is riding his bicycle, then it might be an intrusive
Correct.
stop, because you'd have to get your lights and sirens, because no
Exactly.
cop is running as fast as Lance on his bicycle.
Right.
But in other circumstances,
It may
that
not
might
be.
not happen. So I think what you're saying is it would never not be a seizure, it's just dependent on the circumstances. But going back to something that you said, if the police wanted to stop and ask for information if they were investigating a crime, if this per se rule is adopted, would they ever be able to do that with a bicyclist?
That's exactly the problem. Maybe the police would stop. Maybe it would inhibit the police from performing not only their law enforcement duty, but their public safety duties.
But
And
if they violate the vehicle and traffic law that they're supposed to follow too,
then that would be a predicate for the stop.
correct.
But you're not alleging that happened here.
I'm not, but I'm also stating that that should not be the only factor. The Constitution, both the United
So
States
you want the
Constitution.
police to be able to stop them no matter what?
No, I
On their
want-
subjective?
It has to be an objective basis. The point of the Fourth Amendment and the New York State Constitution guarantees individual rights against unreasonable searches and seizures. And unreasonable requires a reasonable analysis in every single situation.
And it's not unreasonable. I have my bike in motion. I'm going on down the street, and I have cars going by me, and I'm supposed to pay attention to all of it, and I have a police officer yelling at me to stop. Shouldn't there be more required than just because he just wants me to stop?
Again, this is the problem with this per se rule. It can't be enforceable. It's not realistic to be able to say,
But with a
Yeah.
car, you agree, you can't just stop the car.
again, depends, I cited a case, a Second Circuit case in my brief, People versus Adigbadi, which is on page 43 of my brief. And in that particular case, there was a car it was in a parking lot, but it had pulled away, and the police were able, the officer on foot was able to actually stop that car and inquire. And that was not ruled a car stop because it was more akin to a pedestrian
So,
stop.
counsel, let me, as I too am losing the thread of this argument, and I'm sure it's me, not you. So, what is the limitation on, let's just say, with the police officer's authority that you're concerned with, that will be lost if the court were to adopt this per se rule, that your adversary is advocating for?
Well, the issue is...
What is it that cops will not be able to do that puts us all in peril? What would that be?
Well, what about a car riding on a bike path, and the officer can actually communicate with that individual?
I mean, a bike on a bike path.
A bike on a
car
bike path.
yeah.
Or a bike on, even a bike in a bike lane. If the officer can
Okay.
communicate, that
Yes.
bicyclist is exposed to public view, not in a car, the
Okay.
officer can easily communicate with that individual. The
Yeah.
issue becomes, how does a police officer know, by restricting him, saying, wait, is he on a bicycle, but I can talk to him, he's right next to me, wait, I can't stop him unless I have reasonable suspicion. The issue becomes the
But
protection
in
of...
your, under this scenario, what's your position? Could the bicyclist choose to keep biking?
Yes.
Just keep biking, don't answer the question.
Correct.
And then if the officer stops him, what's the situation now?
Then it has to be evaluated, what was his basis for stopping him?
He didn't stop when I asked him to. The rider refused to stop when I asked him to.
And if that's all that he had, then
That the officer,
that
yes,
would be
he
a
or she...
violation? That would, I won't say that that's a seizure, I don't have any other facts other than what you
Well,
indicated.
that was your hypothetical. I think we're kind of in the same place.
Well, again, I'm sorry, did you say a segue?
No, I'm trying, I'm just trying to get...
Same thing,
Trying
same
to
thing.
make some sense of, again, what you see as the great limitation on police authority under this per se rule.
Because the issue, Your Honor,
So
is...
all I'm hearing
Sure.
from you so far is, here's the problem, if an officer can either walk by a bike on foot, which I think even the slowest rider, that would be unusual, let me just put it that way, maybe a tricycle, but otherwise can ride alongside them, lower their window, still watch the road and not hurt anybody, and communicate with this rider, that is what you want an officer to still be able to do. That's the kind of authority that you're concerned will be lost, diminished, somehow jeopardized if we adopt your adversary's per se rule. I just want to understand your
Yes,
argument.
because, but the reason for that, Your Honor, if I add...
Well, you said yes.
Well,
Your answer is yes?
Yes, because the reason for that is jurisprudence requires an officer to look at the totality of the circumstances as to why that individual was stopped,
Can I
whether it
ask-
be on a scooter, inline skates, or a bicycle.
Can I ask you, in this case, if there were a per se rule, if a police officer saw a bulge and saw a defendant with his hand laden with some kind of weight on that bulge, if there were a per se rule, would the police officer be able to stop this bicyclist?
If he saw the bulge.
Just the
Well,
bulge?
according to this court, under DeBoer, a bulge is level 2, telltale sign of a weapon, and if this court enforces this rule that it's a per se seizure, then no, then that police officer would not be able to stop that individual, which is a problem with this per se rule.
The same would be true if the officer saw somebody with a bulge driving a car, a convertible, let's say.
A convertible,
Yeah,
yes.
You still couldn't stop them.
No, without the lights and sirens and the way you'd be able to stop that car, you're saying? Like, just stop seeing a bulge in a convertible?
Yeah.
Would that be enough?
Yeah.
Well,
No, you'd have
no,
to
it
wait for a
wouldn't be
vehicle and
enough. You'd
traffic
have to
law
wait for a traffic
violation to occur,
violation.
which would
correct.
probably
correct.
happen in about 2 blocks, right?
Yeah, exactly. And then you're causing, now, also the issue really, and I know my time is up, if I may just continue. I mean, the whole point of the Fourth Amendment of the New York State Constitution is to prevent, police intrusion based upon a whim and a caprice without any objective reason for stopping these citizens. And that's really what we're looking at here, the totality of the circumstances. If you want to enforce that a bulge in the pocket is now a level 3 seizure, we'll advocate that rule. But the issue is the police have to, as long as the police objectively have a reason at any level, level 1, level 2, level 3, following DeBoer's, this court's jurisdiction, any stop is unsettling to any individual. And that's why the law allows for VTL to be a predicate for the stop, but it doesn't have to be the only, let me step back. Allows the VTL to be a predicate for the police-citizen encounter, but it doesn't have to always be at that level. There are many levels between a level 1 and a seizure, and that's why the police need to be able to determine on a case-by-case basis, because of fluidity of police-citizen encounters, to be able to evaluate a situation, whether it be inline skates, a scooter, a bike. They need to have the flexibility. Again, it's the reasonableness, the totality of the circumstances.
Thank you.
Thank you, Your Honor.
Counsel, you are arguing in the alternative, right? It's a per se rule, or it was an unjustified level 3 de boer intrusion, correct?
Yes, even if even if the court doesn't do a per se rule and instead analyzes this under the totality of the circumstances, it was certainly a seizure. Officer Schell was asked, at some point you yelled out, "Police, stop," to Mr. Rodriguez, correct? Yes. You continued to pursue Mr. Rodriguez when he didn't stop, correct? Yes. Then you commanded him to stop a second time, correct? Correct. You yelled even louder, "Stop the bicycle, please," correct? Yes. And at that point, he did stop, correct? Yes. That's a
Counsel,
seizure.
It seems to me, and correct me, there's no consistent federal rule here, right?
I believe we cited several federal circuits in our brief that did treat bicycles as like cars, but I think the interesting thing about the different federal circuits is that many of them just kind of assumed that bicycles should be treated like cars without actually explicitly addressing it. But I think, just to go back to
But
the...
it seems to me part of that, as I was reading those cases, and I agree with you, some do, seem to assume it, is federally it's kind of an all or nothing rule, right? Either you have a seizure or you have nothing, all bets are off, you can do whatever you want within reason, or you have a seizure. In New York, we have these 2 levels before you get to a seizure, which protects pedestrians, joggers, skateboarders, and you have to get through the 2 levels to even get to a place where you got to, in this case, without a per se rule, and assuming what the court was looking at, right? It's that RR. So shouldn't that affect our analysis here? That it's not all or nothing here. The pedestrian, the bicyclist, the skateboarder, they all have 2 levels of de boer to get through.
Yeah, I think they have 2 levels of de boer to get through when they're in pedestrian areas, when they're in areas that aren't governed by the VTL, where there isn't a lawful order doctrine that requires people to stop when police tell them to stop. We need police to know, for safety reasons, that when they tell people on the roads to stop, that they'll stop. And this is really just solidifying what's already in practice. Police believe that they have the power to seize. Everyone on the road thinks they have the power to
Let's
seize.
say we don't want to do anything in the road rule, and we want to cover bicycles, let's say, or motorized bicycles, or some subset of that. What would our principal dividing line be?
Well, I think it could simply be if the VTL is saying that vehicle has to follow the same rules of the road as the cars, then they're seized,
Where
just
does
like
the
cars.
VTL, in your view, end? Like, what has to follow? If you're on what? If you're on a skateboard, does it apply to you?
I don't think the VTL tells skateboarders that they have to follow the same rules and regulations as cars, but they do say that to bicyclists.
They do say to bikes. Anything else?
And inline skates, I believe,
Okay.
and obviously, I think motorcycles, there might be, I think
So
there's something...
skateboarders don't have to stop if they're in the roadway pursuant to a police order? That's not a responsibility that the VTL places on skateboarders, is that
No,
what you said?
no, it is, because anyone in the roadway has to comply with the lawful order doctrine, and that's why no reasonable person in the road, even if they're on a skateboard, thinks they can just
Okay,
disregard
so
a command to stop.
again, back to my original question. So what, if we don't want to do anything in the roadway, what's a principal dividing line?
Again, if you decide not to do that rule, then you could make a dividing line with what the VTL says should be treated like cars, which would be bikes and inline skates, and you could leave skateboards for another day. But, I do want to point out that the issue that my adversary brings up about, whether police can easily communicate, that isn't the standard. The issue is whether a reasonable person would feel free to leave. And a person on the road doesn't think that they can ignore a police command, and they risk being charged with the lawful order doctrine. If they do, sometimes they risk much more than that.
Can I just ask you one last question, because your light is on, and
Yes.
Going back to something Judge Garcia asked you just a moment ago, if we accept this rule, whether it's just for bicycles or anything in the road, don't you, isn't the natural consequence of that the first two levels of DeBoer melt away? There is no common law right of inquiry for a bicyclist in the road, because it's either stop when told or you're permitted to continue on your way. And all those other DeBoer protections for different kinds of encounters would no longer exist for bicyclists. Isn't that correct?
On the public road,
On the road?
yeah.
Yeah.
Moving bicyclists on a public road, you need a
So
level
the
of
rule
Say
is
it's a
police
very
have to leave them
slow
alone.
bicycle, and the police officer says, hey, can I ask you something? It's no lights and sirens, no, hey, could I ask you something? You can't do that to a car, although they did in the Second Circuit, I guess, there's that one case, but, and they said it wasn't a seizure. Would that be a seizure?
I mean, I think they also did that in Wren, which is one of our most famous cases. They didn't use lights and sirens, but yeah, I think it's a seizure. I think it's the same rule as cars. It has to be, because we can't have different rules for different modes of transportation. There has to be, police have to have a bright line rule that they can even-handedly apply on the roads. In any event, this here was definitely a seizure. This was a command, a submission to the command, and
Then, one last thing, sorry. If you're riding your bicycle in the roadway, it's an automatic level 3. If you're riding your bicycle in Central Park, DeBoer applies?
I think, yeah, I think so. I
Yet
think
yet another
pedestrian
reason to
areas-
get rid of DeBoer, but that's for another day.
Right, I think
written in the past.
pedestrian areas are different, yeah. So we would ask that this court suppress the evidence found as a result of the unlawful search. And thank you very much.
Thank you.